Assalamualaikum warahmatullahi wabarakatuh and salam sejahtera to my Industrial Relations, Regulations and Cybersecurity lecturer, Dr. Muhammad Shanawi bin Muhammad Pirus. Okay, let me introduce myself first. My name is Nur Karimah binti Azmi with matrix number 2020-52-16-71. Today, I would like to present my individual assignment of case of law on cybersecurity. In this case, it involves the public prosecutor from the prosecution against the accused person, Muhammad Faizi bin Abdul Latif. Okay, first, let us take a look at the facts of this case. So, as an overview, this judgment concerns sentences meted out by the court on Muhammad Faizi bin Abdul Latif, which is the accused person who pleaded guilty to 10 charges of improper use of application service, offences in contravention of Section 2331A of the Communications and Multimedia Act 1998, and it is punishable under the section of 2333 of the Act. They involve offences of improper use of application service by knowingly creating and initiating the transmission of obscene communications with intent to annoy another person. The respective obscene communications concern explicit postings of still images and videos depicting male genitalia with lewd and lascivious captions on a Twitter account with the handle of Plug Hijau 002 belonging to the accused person. So, acting upon a public complaint on 7 September 2018, the Malaysian Communications and Multimedia Commission MCMC officer lodged a first information report number EP209/18 regarding active transmissions of obscene communications on several Twitter accounts, and one of them is the Twitter accounts of the accused person. So MCMC's preliminary investigation revealed that there were 10 obscene communications posted on the Twitter account, comprising still images and also videos that depict the male genitalia with inappropriate and lascivious captions between the period of 7 August 2018 to 13 September 2018, which is about 2 months. And on the 2nd of October 2018, the complainant read the obscene communications posted on the Twitter account at Menara MCMC1 Cyberjaya Selangor. On 19 March 2019, the MCMC, with the cooperation of Royal Malaysian Police, conducted a raid at the accused person's house, and they seized a mobile phone, model iPhone 6s Plus, with a hotlink SIM card belonging to the accused person. So next, the counsel from the Legal Aid Department representing the accused person made a fervent plea in mitigation. The counsel said that the accused person is a 25 years old first offender. So he has no previous convictions. He is the youngest of 6 siblings. He is a bachelor who is staying with his mother at a rented house in Masai, Johor. So the counsel further submitted that the accused person is working as an online trader with a salary of around 1,000 ringgit per month. So according to the counsel, he posted obscene communications on the Twitter account was actually to promote his reproductive health product, which is known as Blacha Oil. So the accused person offered an apology for his actions, and accordingly, the counsel urged this court to consider his early pleas of guilt because it has saved judicial time, and therefore they prayed for leniency. Therefore, I could trace a few issues and problems in this case. So the first one is the MCMC prosecuting officer proposed a high amount of fine and a long time of custodial. In the amount imposed on the offender categorized, is the amount proposed is considered as fair and equitable. So if it is, what are the reasons? So the next one is whether the sessions could accept the plea in mitigation, considering his early plea of guilt. And finally, the logic that the session could reject his early pleas of guilt. So let us take a look at the judgment of the case. The penalty for the accused person, Muhammad Faizi bin Abdul Latif, offences in contravention of Section 2331A of the Communications and Multimedia Act 1998, punishable under Section 233(3) of the Act. As you can see, there are 10 charges filed under the accused person with a fine of 5,000 in default of 3 months of imprisonment on each charge, totaling 50,000 in default of 30 months imprisonment. So, given the particular facts of the case, I am of the view that actually a custodial sentence given would not be appropriate. So here are my reasons for this. So the section 233(3) of the Act stated that the maximum sentence is prescribed as a fine not exceeding 50,000 ringgit or imprisonment for a term not exceeding 1 year or 2 both. Hence, imprisonment for a total of 30 months is not mandatory considering the effect such sentence may have on the accused person and his charge of returning to orderly behaviour without the necessity of being incarcerated behind the prison wall for too long. So of course, these offences are serious ones, but there are also some circumstances which is in my view merit consideration. Hence, I have no doubt that a fine and shorter span of custodial is a fitting punishment for the offences made by the accused person. So as you can see in this slide, the analysis shows the prevailing trend of sentencing for the respective offences where guilty pleas were recorded. So this was actually at the first instance of pleas of guilt. So as is apparent, the prevailing trend is a sentence of fine ranging between 5,000 and 10,000 that merely serves as a guide on the prevailing trend of sentencing and the range thereof. It does not in any way take precedence over the judicial discretion on sentencing. So, in sentencing, an admission of guilt in the form of a timely guilt plea is judicially accepted as a mitigating factor. So, in this case, the defendant pleaded guilty at the first instant as soon as the charges were read to him. So, there was no need for the cases to be adjudicated in a timely manner. So, that, in my opinion, justifies leniency. The accused person's guilty pleas obviated the necessity for a protracted trial, sparing the witness with the anguish of having to face the rigors of cross-examination under oath in the court. Of course, this actually saves a lot of judicial time and resources that would otherwise be spent on a trial, right? So for that reason, I personally think that the session court should accept the plea in mitigation, considering his early pleas of guilt. Okay, so however, the damage has been done. The accused must not expect much from the immoral ethics that he had done, right? Because he posted obscene communications, whether it is for business, promotional or commercial advertisement for his products, which is the belacan oil. So not only were the communications themselves vulgar, but they were also riddled with sexual and lascivious captions. His intentional and purposeful acts in posting them for personal gain are repugnant to me. He blatantly ignored the negative consequences of his behavior on social media users that he needed to accept his sentences that was given to him. So obscene social media interactions are widespread in this society, providing no value and only posing a risk. Even worse, the wide social media network hastens the spread of such communications across national borders. So they have the potential to go viral in seconds, in the blink of an eye, well beyond the grasp of most people. And all of this occurs with the simple click of a link. So we must be careful in everything we posted online, regardless of our intention. So as you can see here, these are the references for this assignment. With that, thank you everyone for listening and thank you for your time. Assalamualaikum warahmatullahi wabarakatuh.